A conservative appeals court smacks down the governor's signature law. A judge appointed by former President Trump last week called the Stop Woke Act, promulgated by Governor Ron Desantis, a smokescreen for regulating speech. I'm joined now by criminal defense and civil rights attorney Matt Kachergus, who has himself been deeply involved in Stop Woke legislation, though not this immediate case. Hey, Matt, welcome.
Good morning.
Thanks for being here. We also welcome your comments about the court decision or your questions about the Stop Woke law in general. You can reach us at 904-549-2937. You can also email firstcoastconnect@wjct.org. You can also tag us on Facebook, Instagram, or X. Matt, let's start off with the basics. What did this most recent order say?
Well, when the governor and the legislature passed what's been called the Stop Woke Act, or as the government framed it, the Individual Freedom Act, a series of lawsuits were spawned due to the nature of the regulation, which covered not only schools, K through college, but also the workplace and what employers could instruction that they could provide their employees. And part of the statute prohibited employers from discussing what are called 8 prohibited concepts. And so this particular lawsuit that the appellate court just ruled on dealt with the employer aspect of the Stop Woke Act. And it found that the aspect of the legislation that purported to regulate what employers, private employers, what training that they could give to their employees was unconstitutional. And what's, to kind of strip it down, what the government was trying to do is eliminate DEI, or diversity, equity, and inclusion instruction for its employees, and anti-racism instruction and training. And so what the 11th Circuit, our federal appellate court, found was that it was unconstitutional, that you may disagree with those types of trainings and those concepts, but the government's barring any discussion of that is a bridge too far. It's unconstitutional, or as the court concluded, no matter how controversial the ideas, allowing the government to set the terms of the debate is poison, not the antidote. And so that's what the court found.
Pretty emphatic. The state had tried to argue that this was not a question of speech but conduct. They were saying they were framing it as we're prohibiting these mandatory meetings at which this kind of content would be taught or instructed, specifically to issues of diversity, equity, inclusion, or anything that made people feel bad about, who they were fundamentally because of things that may have been done by other people that look like them. And the court said you can't tackle this as you can't pretend that this is conduct related. It really is speech related, because if they are holding mandatory meetings, the state didn't object to that. They only objected to mandatory meetings if they had this very specific instruction, and that's what the court found was speech related.
Yeah, the court in tackling that argument by the defense, or by the state, was that in order to determine whether the conduct was prohibited, you had to look as to what was being said in this meeting. They claimed that they were just regulating the meetings, but to determine whether it was conduct, they had to look at the content of the expression that was taking place in the meetings. If you were to espouse, information, ideology that was in line with what the governor and the legislature thought, hey, that conduct's fine. But it's only when you espouse ideology that ran contra to this legislation that all of a sudden it became a regulation of conduct. But the court framed it in order to determine whether it's conduct or speech. We have to look at what is being said, and therefore it's a regulation of speech, not conduct.
I'm talking with attorney Matt Kachergus about Florida's Stop Woke Act, which last week, at least one element, got rejected by the 11th Circuit Court of Appeals. Matt, there are these other elements to Stop Woke. One that you handled for a while, which was kind of the K through 12 level of education. There's the college education component, and we can get to that in just a minute. But explain to us what happened with the K through 12 case. That was brought by some local people objecting to these rules, these Stop Woke rules being implemented in, primary education.
Yeah, we've tackled the whole ball of wax. We went after all of it. Our problem was we were a little early to the punch. The court found that we didn't have standing because the various administrative regulations that ultimately got enacted to enforce the statute had not been enacted at the time we filed suit. And the court found we didn't have standing because standing gets evaluated at the time you file suit, and there was no redressability because the way that the statute was going to be enforced hadn't been implemented through the executive office, through regulations.
Meaning there wasn't maybe punishments in place for violating the dictates of the act.
How it was going to be enforced had not been determined yet, and because of that, the court found we didn't have standing.
Even though that did happen later on.
Yes.
You couldn't retroactively have standing.
We could have dismissed and refiled the suit, but other folks, obviously, like, honeyfund.com that just won in the 11th Circuit, and there's another case that was brought by ACLU and NAACP, a guy named Leroy Purnell, I think, is the lead plaintiff. That's now up on appeal for the college aspect of the Stop Woke Act, and other people are carrying the water and running with it, and I wish them well.
Yeah. All right. So the court said that in this particular element, it's not legitimate, but there are, this was done by a 3-member panel of the appellate court, and there are some options to request it be heard by the full panel or appealed. Explain to us what legal steps, and the governor hasn't said yet what he intends to do, but what could happen? Well,
there's a couple of options available to the state. They can file for a regular rehearing, which would just rehear it in front of the 3-judge panel, but they've spoken pretty clearly. You're not going to change their mind. The other option would be to have rehearing en banc, which would be the entire 11th Circuit Court of Appeals sitting together to decide the issue, or they could forego any rehearing and just file a petition for writ of certiorari with the United States Supreme Court and try to have it heard then. This is my speculation. I suspect that they may move for rehearing en banc and then try to take this before the Supremes.
And so en banc would be to, perhaps find some more sympathetic judges to hear the case. But it's worth pointing out, that the circuit judge that wrote this decision was a Trump appointee. And there's no question about his, conservative bona fides. I mean, one of the arguments that they made in their decision relied on a case from Boca Raton where they overturned that city's ban on conversion therapy.
Mm-hmm.
So that was a decision that obviously aligned with a more conservative outlook. But this,
if I may,
yeah.
The other opinion that they cite of 11th Circuit precedent was the restriction that was formerly in place on physicians asking patients about their firearm ownership. Once again, a very conservative concept that they shot down. So
that was the docs with Glocks, or docs versus Glocks, right? That doctors weren't allowed to ask their patients, do you safely store your gun? Do you own a gun? Florida put the kibosh on asking those kind of questions. And then the court said,
you can't do that. It violates the First Amendment. I think that case was Walschlager.
Mm-hmm. So there wouldn't necessarily be a great likelihood that, given the conservative makeup of this 3-panel hearing it with a larger group of all of the jurists would change the outcome.
The law is bad, and I don't know that matters what political affiliation you're in. It violates the First Amendment.
So let's talk about how this dovetails in some ways with other initiatives that the state has taken on that have to do with First Amendment rights. One of them is what's known colloquially as the Don't Say Gay Act, which is a prohibition on certain teachings, mentions of, being gay in the classroom for certain class levels. What else have we seen? You sort of mentioned DEI briefly, but what other initiatives are in this vein of things that should be verboten in the state of Florida?
And it's kind of a spectrum. Like the Stop Woke Act, I think, is just bad on its face because the government's engaging in viewpoint discrimination, and that's just never a good idea. Likewise, what's colloquially been referred to as the Don't Say Gay, I think is bad. Kind of like our case, the district court judge, Windsor, in that case found that the plaintiffs didn't have standing to bring it. That's now up on appeal at the 11th Circuit as well. There's another aspect of Stop Woke regarding the college instruction on the prohibited concepts. That's also before the 11th Circuit. But in that vein, you also have the stripping the Reedy Creek District of its governing authority and restoring that to the state. That's a spinoff of their criticism of Don't Say Gay.
That's the Disney case.
Disney case. And then you have the statute that permits parents to object to books, and we've seen the fallout from that with, schools showing pictures of just empty bookshelves while these reviews are going on. That's also being challenged. And in looking at this, as of June of last year, over $17 million in fees have been paid by the state to litigate this stuff in the courts, and that's June of last year. It's clearly going to be north of 20 million as we sit here today. So there's just a lot of funding being expended on this culture wars, and that I don't even think that accounts for the migrant flights that we're paying for out of other states. So there's just a plethora of these types of statutes that have been challenged at great taxpayer expense.
We're talking about Stop Woke. You are welcome to join our conversation. Give us a call at 904-549-2937. You can also email firstcoastconnect@wjct.org, or you can reach out on social media. It's worth mentioning your law firm was the law firm that fought for the right for gay people to get married. That was your firm. That was
correct. Yeah, that was Brenner versus Scott, and it initially started as a lawsuit to try to recognize gay marriages performed out of state, recognized in the jurisdiction where they were performed, and we were sought out by other plaintiffs, and we expanded that into recognizing the right of gay marriage straight up. We weren't the firm that brought the case before the Supreme Court. That was Ogerfeld and a different plaintiffs out of a different state. But as a result of that decision and our litigation in Florida, we were the ones that legalized gay marriage in Florida.
So I want to get into a little bit of the college level application of Stop Woke and where that argument has gone, because you find that particularly interesting. And I think that even though a lot of people view Stop Woke generally as an infringement on the First Amendment, we're talking about college professors here. And explain to us the argument that the state is making.
Unlike the case that just came down, honeyfund.com, where they argued, we're not regulating speech, we're regulating conduct. With respect to the educational aspects of it, and in particular, the live issue on appeal is the college age students and the college professors. What the state is claiming in that case is rather remarkable, in that they're arguing in court that the professors and likewise the students have no independent First Amendment rights, that whatever the teachers or the professors instruct is government speech, not the professor, but it's government speech. So they can completely control whatever these individuals say in their classroom. And that's a rather breathtaking approach to academic freedom and what we've associated with colleges as being a place that fosters a lot of diverse ideas, the marketplace of ideas, if you will, and the government saying, no, 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 we can completely control all aspects of education and ideology on a college campus.
So they're basically asserting that college professors don't have any First Amendment rights.
Correct. That's scary.
Well, but it does sound like maybe not completely as cut and dried as you might think, hearing that. I mean, we place great faith in the First Amendment. We also, as you say, place great faith in academic freedom in the classroom. And college campuses are a place that you expect to hear more ideas. But there are attorneys that think that the state has a good case when it's asserting that right. So it's not, maybe as cut and dried as you might think. Explain to us what goes into that gray area that might say professors don't have a First Amendment right.
The gray area would be, and I don't know that it's very gray. I don't necessarily agree with that. I think that's bad juju as well. But what they're saying is, because we are the government institution that provides this education, we can control what gets said in that environment, that they are in control. That's it. Full stop. That we don't have to countenance any dissident ideas from our professors.
But there is a case law that the state is pointing to that would allow for, restraining employees of the state. Right?
Well, they're relying on case law that says that the university can set what courses are going to be given and the type of subject matter that they want instruction on, but they've never gone to this level of minutia to control that. Okay, we're going to have this course now. Here's what you can say in it, as opposed to authorizing it generally. We're going to provide for this course, this instruction, but now here's how you have to deliver it.
The comparison I believe that's made sometimes, though, is someone like an anchor at a public, television station reading a script, that being not really in their wheelhouse to like decide one way or the other, that they're tasked with this job and they're going to read from the script. And I think that legally is kind of a comparison that's sometimes made with professors in the classroom.
And that is where the tension lies. At what level, if any, do these professors have academic freedom to discuss the topic more fully than what script is given to you by the government?
We've got a call, Eugene, on the north side. Good morning. Welcome to First Coast Connect.
Hey, good morning to all. Got a quick, brief comment. I was listening to some of the numbers that your person on staff with you this morning mentioned about the amount of money that has been spent from a legal aspect. You can fund some organizations' total balance for a year, and probably so, and give pay raises. That's absurd, the amount of money, government and funds being spent on these projects. And two, before this is all said and done, I know this is apples and oranges, but it's gonna turn some arrows at this JEA project. And I'll take your comments off the air. Have a good day.
Thanks, Eugene. Appreciate that. These are private law firms primarily that are being hired to argue these cases. Is that right?
There's one with respect to the Stop Woke Act. There's a particular law firm out of Washington, D.C., although its principal resides, like many of the high-ranking conservatives, in Naples, Florida. I don't know what it is about that town that draws that. But it's Cooper and Kirk, and they're charging the state $752 an hour.
All right. Keith in Riverside, good morning. Welcome to First Coast Connect.
Good morning. Good morning. I'd just like to point out that the state of Florida has never defined, I don't think it's defined anywhere in the law, what exactly woke is supposed to mean in terms of stopping it. The lawyers for the state acknowledged that the definition of woke was the one that was in the dictionary, which is something that you can't regulate, being attuned or supportive of social justice issues. And I also think it's rich that the state of Florida has 3 holidays honoring the Confederacy and the Confederates, which is, in my mind, indoctrinating people into supporting or agreeing with the Confederacy. But Governor DeSantis never said anything about removing Confederate monuments until he withdrew his campaign, and then all of a sudden, all these bills come forward about restoring the monuments and so forth and so on. So one type of indoctrination is fine, but the other is verboten.
Thanks, Keith. Appreciate that. Matt.
And he's hitting right on the point that the 11th Circuit did, is that this is viewpoint discrimination, meaning that the government is completely prohibiting one set of views from being expressed, while ones that are in line with the current government power structure can go unfettered. And that's what the basis of finding this unconstitutional is that you can't have that type of viewpoint discrimination where the government puts its thumb on the scale in stating what can be discussed.
This is a case, this is an act and a law that is primarily playing out in the courts with lawyers and judges making these decisions. Is there anything that ordinary people should either be following, paying attention to, or doing if they are concerned about laws that step on First Amendment rights?
Like anything else in a democratic system, get out the vote. You can try to, politic your local legislatures to express your disagreement with this stuff, but I don't know that that's going to fall on receptive ears. And so in a democratic system, the ultimate arbiter is voting.
Do you think that this issue has perhaps crested now that the governor is no longer seeking the nation's highest office?
Oh, I think it's very obvious what had happened. This statute and the similar comparator ones, the Don't Say Gay and all that, were rolled out in anticipation of what we now know was Governor DeSantis's presidential run. And this is a way to try to establish a platform for his campaign before he had any kind of national office so that he could draw, and we've seen the debates with Governor Gavin Newsom out of California, where he could plant his flag. This is going to be my, these are, my platforms on my campaign. Here's what I'm running on. And I don't know that a whole lot of consideration went into the legality of it. This seems to be a whole lot of politics.
Matt Kachergus, thank you so much for being here today.
You're welcome.